At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network, it is imperative that anyone addressing the board come forward to the front table and speak into the microphone. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of the BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should also be noted that if false or misleading testimony is provided to the board, any board approval could be revoked at a later time by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding deferrals and withdrawals. Case 2019-212 has been deferred to August 15th. Case 2019-300 has been deferred to August 15th. Case 2019-308 has been deferred to August 15th. And case 2019-321 has been deferred indefinitely. For the members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases identified for the consent agenda, please raise your hand, make sure I see you so we can remove the case from the consent agenda and hear it in its regular order. Please note that on any sidewalk case placed on the consent agenda, the applicant has agreed to planning's recommendations. Mr. Chairman, these are the cases that have been recommended for the consent agenda. Case 2019-293 involving property at 943A 28th Avenue North. Is there anyone here in opposition to case 293? Next, case 2019-305 involving property at 3009 Apple Orchard Trail. Is there anyone here in opposition to case 305? This is your case, right? Okay, so you're not in opposition to it. Is there anyone here in opposition to case 305? Is there anyone, next case is 2019-307 involving property at 3611 Gallatin Pike. Is there anyone here in opposition to case 307? Seeing none, the next case recommended for consent is case 2019-310 involving property at 626 Main Street. Is there anyone here in opposition to case 310? Seeing none, next case 2019-314 involving property at 601 Bell Road. Is there anyone here in opposition to case 314? Next case 2019-316 involving property at 1313 Dickerson Pike. Is there anyone here in opposition to case 316? Next case 2019-320 involving property at 033rd Avenue North. Is there anyone here in opposition to case 320? Next case, 2019-322, involving property at 3503 Elkins Avenue. Is there anyone here in opposition to case 322? Seeing none. To review, Mr. Chairman, the cases on the consent agenda are case 2019-293, 2019-305, 2019-307, 2019-310, 2019-314, 2019-316, 2019-320, 2019-322. And Mr. Chairman, I understand you need to recuse yourself from one of these.
Yeah, I'm going to recuse myself from 322, and it is on the consent agenda because it's a sidewalk case and they've agreed to the planning recommendations, and just by our informal rule, that's how we have handled those cases, but I will not vote on 322. So I'll move the consent agenda for all cases but 322, and then we can take a separate motion without my participation on that case. Got a motion, have a second. Any other discussion? All in favor, say aye. Any opposed? I'll turn it over to the vice chair.
And I will move that 322 be placed on approved for the consent agenda. All in favor? Aye.
Members of the public, if your case was just approved on the consent agenda, you are free to go. Please give our office until Monday to process all the documentation associated with your appeal, at which point you may come in to pursue the permits for which you've applied. Mr. Chairman, before we move on to the cases to be heard, we'd like to take this opportunity to recognize any elected officials who are in attendance. Councilman Hager, would you like to speak now? Yes, August 15th. So I don't see any other council members, so absent any other announcements, Mr. Chairman, we're ready to proceed with the cases.
Okay.
First case for the board to consider today is case 2019 involving property at 4321 Old Hickory Boulevard. Board members, you may recall that this case was considered at the last hearing, or at the last meeting rather, and was deferred so that the applicant could meet with the neighbors and the council member to discuss the sidewalk design. I'll give you a brief review of the case. It is a sidewalk variance request in order to construct a telecommunications tower. This is the zoning map showing you the zoning of the property as R15. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant, and finally, current conditions of the property from recent photographs. Councilman Hager would like to address the board on this case, and then we'll let the applicant proceed.
Thank y'all for letting me come and speak. Let me turn this on.
Yeah, yes, sir. I think you just press the button. There you go.
There you go. We had a meeting, me and Mr. Hargis and one of the neighbors, particularly this sidewalk. The biggest problem we got is about 10 feet out, we have an AT&T fiber line. So we tentatively agreed as to the sidewalk to make a 4-foot grass area and 5 to 6 feet of concrete sidewalk there. I believe 5 feet is what's called for ADA, and I'm working with Public Works to extend that sidewalk all the way down to South Fork. I'll put that in the CIB, but that's kind of where we're at right now. I'm also having a meeting next Thursday, but that'll be concerning the cell tower itself, which they have applied for their permit. So we have to have a community meeting because the tower is within 1,000 feet of residential areas. So we'll have a meeting next Thursday at 6 o'clock. But I think Mr. Hargis, we went out there together with another resident and measured this, and we just can't go past that 10 feet because of the AT&T fiber line that runs along that road.
But you're okay with the 4-foot grass strip and the 4 to 5, the 5 to 6 as largest, which is
close as we can get to the 10-foot mark. That's fine because that keeps it away from the fiber. I think the fiber was what, 10.5 feet, 10 feet.
In most spots, there's one spot you can see it in there. It's a little bit tighter than it's about 9 feet.
Right. Okay. So if we get 4 feet of grass and 5 feet of sidewalk, that's the best we're going to be able to do on that issue. Then my other issue has nothing to do with the BZA as far as the cell tower itself. So that's where we're at right now.
Okay, thank you. Any questions, Councilman?
Thanks, guys. Hi, members. Joey Hargis, Baker Donaldson, 211 Commerce Street. Just following up a little bit what the councilman was talking about, and I need to amend the record a little bit. Our clients actually requested to drop the height of this tower 10 feet. So for the record's purposes, if the secretary can reflect a 140-foot tall cell tower, we've amended our permit to reflect the height. It's not really germane to this body because we're talking about sidewalks. In the upper right, we met with a councilman and a neighbor out there Monday afternoon and took some measurements. And you can see in the upper left-hand photograph that white pole with the orange notation. There's a fiber optic cable vault in that space. So, and our clients are fine with 4-foot grass strip, 5-foot sidewalk. We might have to meander and shrink that a little bit in that spot just to get around that because we can't move it. And there's just so much space. So there might be a little shrinkage it'll always be a 5-foot sidewalk, but that grass strip, we think there's enough room for 5 and 4. The other thing I want to point to you as far as some testimony I made, and I brought some drawings to reflect this, and I'm happy to share with you all. We do not own the property all the way to the ramp, so our sidewalk's going to come up a little bit short of what the public might perceive as connecting the speedway and our space. The owner of the shopping center, that driveway you see in the bottom right photograph, they actually own, and I guess I will turn this in just so y'all have got it. But you'll see in that drawing the sort of how the property flares a little bit. I don't want to use the word spike strip, but you've seen them in developments where it doesn't quite connect. So just for the record's purposes of folks here and folks perhaps watching, I didn't want there to be any perception that we didn't finish the sidewalk. We are going to come up a bit short of that property boundary. Based on my estimation and measurement, I did not have that distance, but it's about 8 feet, 6 to 8 feet short. So, which is actually owned by an adjoining property owner. So if you see that, you've got that in front of you, you kind of see where it flares out a little bit in that spot. So. That's our request, I guess, sort of in summation. This is our request initially was filed to not do anything. This is more of an amended alternative plan, which planning's recommended at least 5-foot sidewalk. We've agreed to scoot it back some.
There were some neighbors in opposition last time.
Yes.
Have you all resolved that? They're okay with this plan? Are they here today? Or?
I'm not going to speak for them. They're here.
Okay.
But the opposition that we spoke about was more about the tower itself, and that's not before this board. It's a permitted use in that zone district. So, but anyway, I yield balance my time. We're not running the clock, so whatever y'all feel is appropriate if I need a rebuttal. So I'll turn it over.
Can I speak again?
Yes, sir.
And what I talked to Mr. Hargis about that 6-foot section, I'm going to get a hold of the owner and get Public Works to call them and see if we can buy that little area, or maybe they might even donate it to finish it on out. So I want it to go all the way to that road by the Speedway.
Right, or just let you build a sidewalk there too.
That's correct. And then Public Works, we'd have to buy the easement and then finish it up. But, I have some neighbors here, but Ms. Winsett went out with me that was here last time. We all measured it together, and I've told them they can come up and speak, but this only has to do with the sidewalks. They just got their request for the permit, so I'm having a meeting next Thursday about the tower itself, which that's not an issue with you all, I know.
Great, thank you.
So that's kind of where we're at. If they want to speak, they're welcome to come speak.
All right.
My name is Randall Butler. I live at 629 Hardinshire Drive in the Southport Village area. This was an email I got in a little bit late on Monday, past your deadline, and I appreciate go ahead and submitting it at this time. Mainly, it has 2 photos. We went out and put flags out there, both at 8 foot and at the 14 feet. as codes requires of both the green zone and the pedestrian walkway. I appreciate plaintiff's attorney coming in, and it looks like 10 feet is all the space we get concerning the fiber optic cable there. I accept that. There was some other concern on when the plaintiff would construct the sidewalk, and we heard somehow that it might be until the rest of the property was developed, and I would like to know if that's the case.
To the extent I understand the question, when does the sidewalk get built last? Because with every construction project, whether it be a cell tower, a house, or an office building, you obviously want to bring your construction equipment on and off the property to build whatever it is you're building. Therefore, the last thing you'll do on virtually every project is either the landscaping or the sidewalks. So the property would not have a use and occupancy to permit until it has met the legal requirements with regard to whatever sidewalk is in fact legally required. In this instance, in all likelihood, although I can't speak for the construction crews who will be handling the permitted work, it's entirely probable that the sidewalk will be the last thing constructed in conjunction with the overall project, and that the use and occupancy would not be greenlit by codes until that too was built in conjunction with the legal requirements.
I guess to your question, the reason that we're here is they're trying to build a cell tower. It requires them to do the sidewalks. This is connected to the cell tower project, not some potential future development.
Correct.
So that's why they're here. It is part of that project. They can't use the cell tower or get their use and occupancy until they have finished the project, as Mr. Michael just said. And so that when, who knows? They have, if they get a variance from us, they have 2 years to pull their building permit based on that variance. And so it just really is up to the person who owns the property or is going to do that project to when that happens. But before they can get a use and occupancy, they have to meet the code requirement, which is the sidewalk or the variance that we allow.
And to my knowledge, I think the access to the cell tower and the construction thereof is through the parking lot. Is that correct, Mr. Hargis?
I'm sure, yeah. I'm happy to address that. Yeah, it will be through existing.
So that has no bearing on whether the sidewalk is going to impede any construction travel. So, the neighborhood association would like for it to go ahead and get built, at the time of the tower construction and not sometime after. Thank you very much.
Great, thank you. Any questions? All right.
If I could, Mr. Chairman, just cover that. In case there's no confusion. The sidewalks themselves will be constructed let me back up a little bit. This development was originally approved for 50,000 square feet of office. We're going to build the sidewalks at the time of our construction of the tower, not at some future point. So as part of what Mr. Michael talked about, for us to get the green light from codes to turn the power on, we'll have those sidewalks that have to be constructed as part of that. So it'll occur contemporaneous with our construction of the thing.
Great. Anything else to add?
No, just I thank the councilman for meeting with us and talking, and planning department for the 5-foot sidewalk. That's what's out there now on the other side of the street, and further down is just a straight 5-foot sidewalk right at the curb. My guess is that's why planning said what they did, but we're happy to accommodate grass strip and get some folks away from the road as much as we can with, I hope, all the public's understanding, except for that little spot in the middle. I can't move that, so It'll be a little bit narrow there. But okay.
Great.
Thank you.
We will close the public hearing. Any discussion? I mean, this is a case where it would have been on consent agenda originally because they had agreed to planning's recommendation, which was simply a 5-foot sidewalk, and the neighbors and the councilman of the district felt, and I think rightly so, based on where we are now, that there could be at least some grass strip, and I'm pretty happy that they were able to have a grass strip and a sidewalk. So if there's anybody else have anything to comment, I'll move that we approve the variance, the sidewalk request variance, maintaining a 4-foot grass strip and a 5 to 6 foot sidewalk along the property, with the exception of the AT&T fiber box that was described in this hearing, and in that situation, the grass strip would be as close to 4 feet as possible, and the sidewalk would be 5 foot at least as a minimum in that small area. Got a motion, have a second. Any other discussion? All in favor, say aye. Aye. Any opposed? That passes. Good luck. Thank you.
Next case for the board to consider is case 2019-313 involving property at 331 Richardson Avenue. This is a request from variance from setback requirements to construct an addition to an existing garage and convert that garage to a detached accessory dwelling unit. Zoning map here shows you the zoning of the property is SP. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant is before you now. And here are the pictures from a recent site visit showing you the current conditions of the property. Is there anyone here in opposition to case 313? Seeing none, the appellant will have 5 minutes to address the board. Please come forward to the table and identify yourself by name and address.
Thank you. My name is Adam Ohlendorf. I reside at 331 Richardson Avenue in Nashville. And thank you for the opportunity to make my case to you this afternoon. My reason for requesting a variance to the setbacks is so that, basically so that I can keep the existing garage, cinder block garage that is on the property line, just about on the property line to the north border and about a foot off the property line to the east border. I suppose my hope in obtaining the variance would be to just keep the existing structure, to not have to knock it down, and then to add on approximately 180 square feet so that I can put in a bathroom and a small kitchen. I've spoken to my neighbors at 1200 Lishy, Josh and Jamie Stump, and 1202 Lishy, Sean Lewis. They all said that they had no problem with it. Mr. Lewis asked if I would consider putting in some gravel to the north of the garage. There's a little strip, a sort of an easement that gives his property on Lishy access to the alley. Mr. Lewis asked if I would be willing to put in some gravel on the north side there, and I'd be happy to do that, just to make it easier for his tenants to access the alley. I also sent in a rendering. I wonder if that made it to the board. I realize that this isn't necessarily the purview of this hearing, but wanted to make clear and spoke to members of the neighborhood association, including Mr. Russell Kirchner and Jason Stalcup, to clarify with them that as far as moving forward, should this variance be approved, that the detached accessory dwelling unit that I would build would be architecturally identical to my house, so sort of a mini-me, if you will, to match the house, and of course adhere to the requirements of the SB.
Is there a site? I thought I remember seeing a site plan at some point, but I don't have a site plan. And
Mr. Chairman, I did bring one with me if you'd like me to share a copy.
Yeah, that would be great. But I remember seeing one in some packet, but I don't see it in the latest packet we have.
I believe whatever has been submitted to us would be in the packet. And what is before you now is what was, I guess, submitted with the application.
If I may, I do believe I submitted this site plan as well with my application, which is a little different than the what appears to be the survey. May I submit this?
Yes.
Thank you, Mr. Chairman.
current square footage of the existing garage?
So it's 24 by 12, so it's about 280 square feet.
Okay, thank you.
Thank you.
It's just a one-story addition, or is it?
That's correct, just a one-story addition. And I did share via email before the deadline a rendering. I wonder if that made it in. I brought some copies of that as well, if that's helpful. It looks like that.
Sure, yeah, I've seen it. And I'll say it's a very nice rendering, and when in your application, you talked about adding onto the existing garage, and the rendering looks like a brand-new garage, and so I think you explained the cinder block aspect of which I think at least helps me understand about keeping the structure. But when I saw the rendering, I thought, boy, that looks like a brand new garage. But you do intend to keep the existing structure as much as you can.
Yes, Mr. Chairman. And in fact, the existing garage looks just like the house because the cinder block is covered with hardy board, just as the house is.
So the only thing I guess that to me that maybe needs a little explanation is on your site plan, you have the existing property line, which you're a foot away, but then you have the neighbor's fence, which looks like it's much further away.
That's correct.
Help me understand why the neighbor's fence is so far away from your property line.
I understand the question, absolutely. For whatever it's worth, when I bought the house, this is exactly the way I bought it. When I had the survey conducted, the surveyor explained to me that he couldn't find any nails in the alley that gave him a super concrete way of drawing up the survey. So he said, I can sort of go off this one nail that's way down the alley, or I can go off this other nail. If I go off the one, then it seems to make the most sense. It seems to also put the neighbor's fence way into their yard. And so I just sort of went with him on that. But I guess the short answer is that was just sort of the way it was when I bought the house in 2014 or early 15.
Okay, so I guess the effective variance is actually greater than a foot if you just assume that the neighbor who had that fence there before 2014 is happy with the fence being there. And it sounds like there may be some confusion on that. I just wanted to make sure because if there's a fence that's further off, I was just trying to understand that. Thanks.
Does that explain? I mean, there is some ambiguity, I think, but thank you, sir.
Any other questions? Is there anything else that you'd like to add?
Is there anything else that would be helpful for me to add? For whatever it's worth, I did speak, as I mentioned, I spoke to all of my neighbors with whom I share property line, and they all said that they had no issue with it, and were happy that I had reached out, but wouldn't mind. I'm eager to keep that existing building and sort of make as little impact as possible. And obviously, it would save me quite a bit of money to be able to keep the existing structure if I could.
Right. All right. We will close the public hearing and discuss. Thoughts?
I don't have an issue with it. I agree with you, Mr. Taylor, that because the fence it's really not as much of a variance as we're talking about because that existing fence. I don't have a problem with the request.
Yeah.
I was just going to say that I appreciate how prepared the applicant was with the renderings and showing us what he plans to do, because that helped sort of explain what he's looking for. So.
Well, and the variance on the side is really I don't want to use offensive in the wrong way, but it's the part that really adds to the nonconformity. I mean, the back is existing, the side's existing, and so you're adding there. But the neighbor That's the one where the fence is actually further away, and there was some testimony as to maybe perhaps some ambiguity on the line, and the fence may support that, may not, I don't know, but if he's talked to both neighbors and both neighbors are okay, then I tend to agree. Well, I will move that we approve the variance, the setback variances based on the plan that was submitted by the applicant.
Do we want to also, I'm sorry if I could offer a friendly, do we want to include that?
Yeah, and that one condition is that the gravel that was testified to, the gravel request testified to, based on the conversation of the neighbor, would be part of the plan.
I'll second that.
Have a motion, have a second. Any other thoughts? All in favor, say aye.
Aye.
Any opposed? Good luck. Thank you.
Thank you so much. Appreciate your time.
We will move on now to the short-term rental portion of the docket. First short-term rental case is case 2019-302 involving property at 1708 Elm Run Way, challenging the zoning administrator's denial of a short-term rental permit. Is the applicant here on this case? Craig and Andrea Brooks. Are you here on behalf of the applicant? We are. Okay. So before we proceed, or before y'all can go ahead and come to the front table, Mr. Osborne, he is here to present the case on behalf of staff. I would note one thing that Mr. Osborne can elaborate on when he gets up here. This case was heard in environmental court for operating without a valid permit, and an injunction was put down, so there is an existing court order on this property that was recently put down against.
What is the court order?
That there shall be a one-year waiting period. And as the board knows, the state law dictates that the local law in effect at the time the permit was obtained is a law that governs. I believe this is, and again, Mr. Osborne can elaborate on this, but I believe this was a case where they operated on an expired permit. We sent an abate notice. They continued to operate, so we took them to environmental court. Because the law in effect at the time the permit was obtained mandated a one-year injunction by the court, that's what the court put down. So they are currently under a one-year injunction.
And so I'll ask our legal counsel, our three lawyers over there, why are we hearing it, and what could we possibly do?
There's a key determination as to whether or not staff just made a mistake on the facts at issue in the case. You may remember the original iteration of the short-term rental law did not afford the board any ability to reduce a one-year wait period. However, in the event that the board had determined that staff just made a factual error as to whether or not there was operation without a permit, then that's something you could overturn, thus greenlighting a permit. That would have nothing to do with a one-year wait so much as the determination of, no, you just got the facts wrong, guys. We find differently. So that's what's before you today. If you determine that, no, there was not, in fact, a violation by operating outside of the scope of a legal permit, then that would be a basis by which it would be overturned, and the permitted operation would be permitted once again, or could be permitted once again. If, however, the board determines that there was, in fact, a violation, then that does trigger the one-year wait period under the ordinance that was in effect at this time, and therefore, and under that ordinance, you did not, and therefore do not today, have the ability to reduce that one-year wait period.
And
If there's a one-year injunction down from the General Sessions Court, how do we have jurisdiction over this?
Is a legal argument that's been made both ways by parties before this board. It's the position of the zoning division of the Codes Department that you do not have jurisdiction to overcome an injunction of the court. However, folks are here today, and so we'll let the board proceed as they see fit, of course.
okay, Mr. Osborne.
All right, so we found out about this one and sent a notice on September 5th of 2018 for not having a short-term rental permit. On October 5th of 2018, another notice was sent. This property operated from July of 2016 to April of 2019. It did have a permit that was issued on July 27th of 2016, and it was renewed in 2017, but not in 2018. It operated 57 times and approximately 20 times illegally after the permit expired. On January 24th of 2019, I had issued a warrant for operating without a permit. The advertisement was removed around May 24th. And on June 25th was the date that we had it in court.
Okay. All right. If you would state your name, I'm sorry, is there any questions for Mr. Osborne?
I understood that. What were the notices in September and October of 2018?
So the first one was just you don't have a short-term rental permit. The second one was you don't have a short-term rental permit and you need to pay taxes.
Okay. And was this one that you found through your software?
Yes, ma'am.
Okay. And then it was later in 2019 when you saw that they came offline, not until May of 19?
Not until May of 19, correct.
Okay. And was there one other notice sent after September, October? Did you say there was one in January of 19?
In January of 19, that's when I sent the warrant.
Got it. Thank you.
And so I guess just to be clear too, though, they did not have a permit after the 27th of July 2018.
Correct.
And you do have evidence through reviews and other means that they did rent after that.
Correct.
Okay.
And they had received notice of that, just making sure the record's clear, that they did not have a permit at that point in time and they continued to rent.
I'm not sure if they've received the notices we sent, but we did send the notices.
Okay. To the address.
To the address on file, yes, sir.
All right. If you could state your name and tell us why you're here.
Right there, got it. Thank you. My name is Johnny Lee. I manage the property for Craig and Andrea Brooks, and James works alongside me here. We can't really. The reason we're here is not to debate whether you guys have the ability to overturn a one-year hiatus and so on and so forth. We're here on behalf of Craig and Andrea purely because they cannot be here today. They live in Canada. We've operated this as a short-term vacation rental for them since 2016, and they didn't receive any of those notices. They were operating completely unbeknownst to them without the knowledge that they had neglected to renew that permit. So their plea is we have done this, everything above board as far as they have known from day one, and they completely forgot when it came to the renewal in 2018. And only by fortune that they were actually staying in the property in May of 2019 this year did they find out about this, because I believe that's when the sheriff came to the door and they were like, whoa, what? So they had not received any of that. I mean, that's the reason we're here to plea on behalf of reducing that sentence, is they really want to engage in what they set out to do with this property from day one. I don't know if, did you guys receive this package of information that was sent prior to Monday or not? We did print out 8 more copies just in case.
I don't, you can submit those if you'd like and hand those out. I don't see.
It is it's a letter from Craig and Andrea. It is testimonials from all the neighbors around them that have known and they've been operating it and have never noticed any, disturbances whatsoever. Lots of different stuff about them and why they bought it, why they, their passion of being in Nashville. And they visit 2 or 3 times a year, and this is purely a mistake. And it's had significant financial ramifications to them, because as soon as we were made aware of it, we had to cancel, tens of thousands of dollars worth of bookings and so on and so forth. So we've done everything by the book. Beyond, we had no idea that they had neglected to renew, unfortunately. So. Right.
And this isn't the first time that we've had this situation where people didn't, and I'll say claimed they didn't get the information. And I mean, that's your claim, and I have no doubt that it's. Yeah. I don't have a reason to doubt that claim. And part of the challenge that we're trying to deal with here is that we have a court that is ruled on this case, and that court takes precedent over this board, and so that's. Yeah. It may very well be a situation, and this board has looked at cases of expired permits somewhat leniently in the sense that it's understood that, because you don't get a notice to renew and that type of thing, that somebody can, forget and just not renew. But once it gets to court, that becomes a whole different matter. And so I'm really not sure what we can do, but I just wanted to make sure you understood that before we deliberate.
Yeah, completely understood. I mean,
yes, sir.
Can I add something? Yeah, my name's James Ellis. I work for Johnny's management company. They were paying taxes all this time while they had the permit lapse, so they weren't trying to defraud anyone. If they'd known about that for the sake of just a $50 permit renewal fee, it's not something they were trying to get out of having to pay. And I think in this case, I know the permit has been you have a 1-year penalty period to go through. I think they'd be willing to do that just as long as they can get the same permit back. The problem is these permits are no longer issued by Davidson County anymore, being non-owner occupied for these particular zoned of properties.
And I will say that there are people on this board that may be empathetic with that and people that aren't, but the reality is we have no authority over that. We can't say, hey, it was an honest mistake, and therefore you should be able to do. I mean, that's just not how it works. I mean, the permit expires, and once it expires, there is no permit. You have to reapply for a permit. If you're not eligible to reapply for a permit because the law has changed, then that's just how it is. So, I mean, there's nothing I can do, or anybody on this board can do to that. As empathetic as some of us might be to that situation.
So it's really and truly, if they want to take that battle up, it's really there's nothing that they can really do about that in regards to the way laws have changed. Is that your understanding?
Yes, is that?
Yeah.
I'm looking at our attorney.
Sorry, what was the question?
Our attorney's nodding, and yes.
So that $50 renewal has turned into a horrible nightmare for them, that's for sure. So
understood.
Yeah.
Understood. Is there anything else that you all would like to add?
I mean, I'm not so sure that you guys really could do anything about it. It's a heartbreaking story. If we'd known about it, there's something we could have done about it. We just didn't. We'd love to at least give you guys this stuff as well, because I mean, the neighbor was picking up the mail, and there's they even took snapshots of no mail, his mail, etc. And just nothing came through. So I don't know how we could ever prove that the mail didn't arrive. That's nothing we can do, I guess. But
right.
Anything you want to add?
Yeah, I mean, they are a part of the community as well. The neighbors, whenever they're in town, the neighbors come over for dinner, and, everybody loves them. They're real good characters, and they are, the signs of the benefits that short-term rentals can bring to a community.
Right. And that was clear through the letters that came through the packet. I totally understand.
Oh, great. So you did get that.
Yeah.
Okay. Yeah.
Any other questions? Anything else to add?
No, so I mean, even if you guys were to discuss whether you could reduce that from a year to 3 months or 4 months, it really wouldn't have any ramifications on us being able to get the same permit again, is my understanding. So
that's right.
Yeah. Okay.
All right. Well, we will close the public hearing and discuss. I do think this is one of those unfortunate situations where, as the applicant said, failure to renew your $50 permit has had big implications, but that's the law that the council passed, and there's really no path for us to fix this. Were we to want to fix this, and the fact that it's gone to environmental court is one of those things where it's already gone to the greater authority than us. So, I mean, I'll unless anybody has anything to.
I just would make the comment that, and I had this opinion all along, I don't think it's appropriate to treat people that were permitted and were following the law more harshly than people that were not. And we have people come before us many times that had never gotten a permit, yet they were able to obtain that quickly. So I understand what the law is, but I'm opposed to the outcome in this case.
Well, and I 100% agree with that. because I do think that this is a kind of situation that is, to me, it feels extraordinarily unfair, especially if someone's paying their taxes and doing everything like they were supposed to, but just, like I said, for whatever reason, forgot to renew.
And Mr. Chairman, I might point one thing out that the board may want to consider as you deliberate. Because we have an existing injunction that was entered by the court, that will run from the date that injunction was put down. If the board acts on this now, there would be another waiting period that the applicant would have to wait out, which is later in time, and so therefore that's ultimately extending the amount of time they have to wait. So that's something for the board to consider if you do want to act on this or not, to the extent that matters. If you do not act, the injunction by the court would still stand, but it would run earlier than any order that this body puts down.
When did it go down?
June 25, so approximately 37 days ago, thus potentially buying up to, 5 more weeks?
Sure. Not a huge difference, but for people that are in that world, that may make a difference to them.
So basically, you would say,
If this board finds that the zoning administrator did not err, and therefore a 1 year waiting, by the law at the time, a 1 year waiting period from the time the board made a determination would also go into effect. So we would ultimately have 2 waiting periods that they are required to wait out.
So do they have to withdraw, or could we decline to vote? What is the proper way to do that?
They could withdraw their case. They could choose to defer indefinitely. The board could defer it indefinitely. So the board can take action because it's before you by deferring indefinitely, or the result is the same, but it's.
Or we could deny.
Or you could deny their appeal, and as I said, that would give them a 1 year waiting period from today's date.
Okay. I'm still having a difficult time understanding the jurisdictional issue of how we can even do anything at this point. I mean, I'm not usually in the habit of saying I didn't like what the judge said. So
well, and that argument is brought, as Mr. Michael said, has been brought before the board previously. I think there are, and Metro Legal may feel free to correct me if I'm saying this incorrectly, but you've got 2 issues. The court considered whether or not they operated without a permit. The court determined they operated without a permit, and therefore they were given a 1 year injunction. What's before the board today is if the zoning administrator erred in denying a permit. So it's nuanced, but it's 2 different issues. One is considered by the court and one is considered by the board. So you would be acting on whether or not the zoning administrator erred in denying this permit. If you determine that the zoning administrator did not err, and therefore a 1 year waiting period starts, the 2 would run concurrently, then the court order would run out, and then because they're running concurrently, you would have another 5 to 6 weeks until this order runs out.
May I ask one question? The basis of the denial, which is the subject of the item A appeal, is failure to obtain a permit. Is that, what was the basis of the?
The basis of the denial was operating on an expired permit.
Okay.
So we did not, which is the equivalent of operating without a permit, because the permit's expired, and the law dictates that if you operate without a permit, you can't get a permit for a year.
So there are just 2. One is an administrative track that it was on, and one is on a judicial track. But the outcome may ultimately essentially be the same,
right,
based on what the law was at the time that has to be evaluated by this board, which did not give this board any jurisdiction to reduce the 1 year.
That's right.
Just wanted to make sure I was with you guys as well, because I was not the attorney that worked on this case in environmental court, but was gathering everything from what you all were saying just now. So yeah, so you would have jurisdiction, but only on the limited issue that came before the zoning administrator, as Ms. Lamb has carefully articulated.
I know I should have learned this by now, but I'm still trying to. Is it the state law now says the law in effect at the time that you receive the permit is what controls? Is that right?
That's correct.
And in this case, would it be the second permit that expired or the first permit? When does that date
The first,
begin?
when the permit was originally obtained, which was, I think, 2016, that's the law that governs. I think the law says when the permit is obtained. So
When the initial
we don't, right, we
permit
don't
is
view the
obtained.
renewal as obtaining a new permit. It's just renewing that permit that was originally obtained back in 2016. So when it was that law, when the permit was originally obtained, is the law that governs.
So you get the good and the bad with that?
That's right. You got to take the good with the bad.
May I ask a question?
You know, the public hearing's closed, and there'll be plenty of time. I mean, you can talk to the codes folks after, afterwards. So, I mean, so.
Sorry.
I'm going to make a motion that we deny, which is just basically, and again, it's new eyes on it, but it's the same result in the end. It's just, I'm just uncomfortable going any other way. I may not go very far, but they've had several bites at this apple at this point in time.
So the motion is
to deny the request.
And that the zoning administrator did not err.
Correct.
All right, we have a motion on the table. Is there a second? I'll move that we defer this case indefinitely because while I believe that the zoning administrator did not err, I also believe that it is an unfair situation for the applicant to have an additional penalty imposed beyond what the environmental court was required to impose based on their finding. And by deferring this indefinitely, they will still have their 1-year penalty, but it will expire sooner than a year from today. So I have a motion, I have a second. Any other discussion? All in favor, say aye. Any opposed? That passes 4-1. Yep.
The last case on today's docket is case 2019-303 involving property at 1010B Caldwell Avenue. Again, this is another one that Mr. Osborne can make the presentation on behalf of staff. I would note for the board to consider, this case was previously heard by the board on March 3rd. And the board denied the appeal at that point. They have apparently reapplied. Mr. Osborne can weigh in on this. It had to do with a permit that was revoked and then a new owner was added, and it's a little bit complicated with multi-tiers, but Mr. Osborne can present for the staff, and if there are any questions, we're happy to answer them.
Excuse me, my case is labeled 2019-303, but that's not the same case. It's a different address and everything. Address of your case? 740 First Avenue North. Step out with me and go look for your case.
Looking at the application, case 2019-303 is for 1010B Caldwell Avenue.
We'll go figure out which one this is.
So is the applicant here? Might want to take a quick break while we figure this out. Are y'all here? Which case are y'all here on?
314.
That's not on the docket. We might want to take a quick break for us to figure out what's going on.
Okay. Are there other people here who think they have a case today? You said 314? If you think you have a case today, come and talk to Mr. Michael or Ms. Lamb. Then we'll take just a second to try to figure all this out.
Are you the applicant?
Oh, I'm sorry.
You won.
Thank you.
All right.
Congratulations.
All right.
Right.
I think that what we have learned is that the case that is 303 that had a mistake on the docket was actually not noticed properly, and so at no fault of the applicant. And so we will have this case heard as quickly as we can after.
I believe it'll be the first meeting in September because we've got a legal notice requires 21 days, and that's more than, the next meeting is only 14 days away, so we'll do it the first meeting in September.
We'll do it the first meeting in September, but I will ask that we put this at the very first of the docket above all other cases, not at the, not at the beginning of the short-term rental, but at the first of all the cases that we hear that day, just out of respect for the applicant coming down and knowing that this situation is no fault of theirs.
That's right.
So, okay, well, good. With that, we are adjourned.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.